Hello there and welcome to our weekly video. Today's video is going to cover the questions that we typically get from people that are in a divorce and are looking to protect their interests whenever real estate is involved in the asset division. This particular video would also apply in the case where maybe siblings inherited a property together and that type of property is not easily divided. It's not a multi-unit property such as a triplex or duplex. And so there has to be some sort of division and there have to be certain documents that will be carefully crafted to protect every party that's involved. I'll go through the example of a divorce first because that's the most common scenario. And then we can also reference the case where the people are not married or never were married, but they just happen to be co-tenants together. They own the property together because maybe they inherited it. All right, so what is it that people are most concerned about? People want to know, how should I structure the agreement if we're going to have settlement talks, settlement conference, mediation, or things like that? And then the next question they want to know is, if we do come to an agreement where I'm walking away and I'm getting some other maybe personal assets in exchange for me walking away from the real property, how do I protect my credit profile? How do I protect my credit score from tanking, especially in the case where my ex would be taking over the mortgage payments and all the property tax payments and things like that? So that's the second question that people typically are concerned about. And then the third thing that they're concerned about is in the instance where there is a buyout agreement where spouse A is supposed to buy spouse B out by paying a certain amount of money, but does not have all that money up front. So there's a payment plan or some sort of payment schedule for spouse A to pay over a period of years. So how do I, as spouse B, protect myself to ensure that A, I get all of those payments that were due to me on time and all of them, and also B, to also ensure again that my ex is paying all of the mortgage and everything else needed that's related to upkeep of that property and protecting the collateral. So those are the things people worry about. And then lastly, they ask, things happen in life and it's possible that this person might stop paying at some point or is unable to pay at some point. What can I do about it then? What are my options? What's my recourse? So this is all that we're going to cover in this video. It's going to should be a short video, I think. So the first thing that people have to keep in mind is those are the possibilities in coming to an agreement. The possibilities in coming to an agreement are more varied than if a divorce is contentious to the extent that a judge is the one that makes the decision. If the judge is the one making the decision, that means he's going to award the real estate to one or both parties. And then whatever comes with that is what needs to be done. You really wouldn't have a lot of wiggle room as to negotiating in that instance. But what you do have to ensure then is after the judge has made an award, the lawyers or the parties, if they don't have lawyers, are responsible for drafting the appropriate property documents to cement that order or to make sure the order is completely laid out. The terms of whatever it was, the award that the judge made should be inside the particular documents. It should correspond to the orders, and nothing should be missing that might jeopardize your position in future. So those are the questions that people would have, and those are the things to keep in mind. Now we'll talk about when people are actually having more leverage by coming to a settlement agreement, and also some of this would also be the things that a judge might order anyway. So the first instance, as I said, one spouse might say, I don't care about this property. I don't want anything to do with it as long as you continue to pay the mortgage and property taxes and the homeowner's insurance payments. So that's fairly straightforward. The thing that causes questions is the fact that usually there are two names already on title, right? And sometimes the two names are also on the loan, because remember, the title is something else. It goes together, with the loan, but it's separate from the loan itself. So sometimes you'll have two names on the title because it's a marital property state, but only one person qualified to be able to get the mortgage. So there'll be only one name on the mortgage. If that's the case, then nothing needs to be done extra, because if you're not the person that's on the mortgage, all you have to do is sign over a warranty deed to your ex, and then your ex, if he doesn't make the payments, is not going to damage your credit because you're not on the loan. So that's the first scenario. The second scenario is where, yes, you do want to walk away, but you are actually still obligated under the loan, because the mortgage companies don't really care whether you've had a divorce. All they know is that you promised to pay them a certain amount in exchange for getting that property. So the mortgage company isn't going to be very sympathetic, but they do understand that people can assume a mortgage, a loan, if there's a divorce. So spouse A can then assume all of the responsibilities that were both yours, and you can sign over, again, a warranty deed. But this time around, because your name was also on the loan, you need additional protection. You need to have your ex, spouse A, sign a deed of trust to secure the assumption. So he's going to sign something to give you certain rights in case he defaults. That document also serves as notice to everybody else out there in the world. The deed of trust serves to alert everybody out there to the fact that your ex has agreed that he will be the only one responsible now for making all of the related payments on any liens that were existing already, and also any liens that he creates afterwards. The document also outlines all of the rights that you have should he default. That same deed of trust would also state what could trigger a default. The things that will trigger a default will be if he stops making payments on the mortgage, the monthly mortgage payments, if he stops making property tax payments as they come due, if he stops paying the homeowner's insurance premium on that property. And those will be things that will trigger default. And the other thing that could trigger action on your part, it's not exactly a default, but it triggers the option to move forward with a forced sale. And that's if he tries to transfer the property without your consent or your permission. So he needs to notify you first before trying to transfer that property to someone else by selling it or gifting it or whatever. But sometimes the deeds of trust don't have that language in there. I like that to be in there because it's an added layer of protection for you. So those are the things that are in there. And then your rights mostly have to do with the right to step in and intervene to protect that property if your ex defaults on the payments. So you could intervene by stepping in and starting to make the mortgage payments. Let's say he's falling behind a couple of months. Of course, you'll notice because you're still probably able to log into the account, or maybe you're getting a copy of the statements as well, or seeing something on your credit report saying that you're late on the payments. Remember, because your name is still on the loan at the lender's end. So you could start making the payments and he'll owe you a reimbursement for those payments, plus any additional fees that you incur in hiring an attorney to do the collection for you, to collect from him. So he'll owe you that. And then the other right that you have, of course, is to step in and pay the property taxes if he, again, falls behind on paying those. And the same thing with homeowners insurance policy premiums. So all of those you have to do because you're protecting the collateral. Even though you're no longer obligated on the loan, you're only protecting it in this case so that your credit score is not affected negatively too much. So those are the options you have. And then the biggest right that you have, though, is that right to force a sale, to do a foreclosure of your own. And it will state in the deed of trust that once there's an event of default and it's not cured by your ex, then you can actually have a trustee go ahead and foreclose
on 100% of the property. Remember, you only gave him your 50% share in the property, not 100%, because you never had 100% share. It was half and half. But once he defaults on it, on the deed of trust, on the agreement, then you can foreclose all of the property. The only thing that changes once you foreclose on the property is that you don't keep all of the money that you get from that sale. Obviously, you can do a foreclosure. You do have to notify the mortgage lender probably before you move forward with all that. But once you sell the property, you pay the mortgage company whatever the payoff balance is on the mortgage. So there are priorities of disbursements or distributions that must be made. The prior lien is first, so the mortgage company gets paid, and then if you're owed any reimbursements for the property taxes that you covered for him and for the mortgage payments that you covered for him, hopefully you've been keeping a detailed accounting, then you would get reimbursed next after all the junior liens that were, in line after the mortgage, such as property tax liens or anything like that. You pay all those, and then you pay yourself, and then the balance left goes to your ex because you had transferred all the interest to him anyway. So that's how the foreclosure would work. And then the thing that I also like to be inside the deed of trust is that if he starts falling behind on the property taxes, for instance, instead of going out to a company that will give him a loan to cover the property taxes, you should have the right of first refusal. He should approach you first so that he doesn't create that unnecessary lien against the property, and that will be a tax lien, and those are very, very powerful, and they could also lead to a foreclosure. So that language I also like to be inside the deed of trust to secure assumption. Those are the main things. The other thing that's important to put in there in case you have to cover some of his payments that he misses to protect your own credit score is to have language in there that says that if there's ever a tenant inside that house, you have a right to collect the rent. So there's an assignment of rents that language should be inside the deed of trust to secure assumption in case he's using that property as a rental property and not paying the mortgage, even though he's getting money from tenants. So you can step in and then order them to pay you directly if you're indeed owed a reimbursement, or you can ask them to pay you directly so that you can turn around and use that money to settle the mortgage company. So those are the main provisions that I would say you should have a discussion with your lawyer about, that they should have that inside your deed of trust if you're the party that's walking away from the property. And then ultimately you cannot stop somebody from falling back on payments, but those are the things that you can do, these things that I just mentioned. And ultimately the most escalated step is to then do a foreclosure if you must. And that's okay because it's a private foreclosure in a sense. It's not going to go against your credit score like the one that a mortgage company would do. You're essentially selling the property in order to pay off the mortgage anyway, and then to pay yourself for whatever you're owed. So those are the main things inside the deed of trust, and it's typically called a deed of trust to secure assumption in that case. The other thing that's important to note is that the warranty deed would be called a special warranty deed. Typically, that's the document that you would sign if you're the giver, you're the grantor. So you're the one giving away your right to that other spouse. Maybe you're not necessarily giving it away for free, but in exchange for something that you got inside the divorce division, the asset division or the debt division. Maybe he got more debt than you, and so you were okay to walk away. So that would be a special warranty deed, and it's just named that way because it's a special circumstance that triggered it. And then inside the special warranty deed, it just has the usual information, the names of the parties, your addresses, who is the grantor, the giver, and who is the grantee, the getter. And then it'll also have the property description, of course, and it will have the fact that the consideration is as part of the settlement of a divorce case, and it will have the case number typically, the court name, county, and all of that. And so that's what the special warranty deed is. It's the conveyance document. It's the document that gives. And that's going to be signed by the giver, whoever is giving their interest to the other party. And then the deed of trust is actually it's an acknowledgement of the debt itself that secures the promises made by the getter. So the deed of trust will be, I promise to pay the mortgage company, or I promise to pay the mortgage company, and then I also promise to pay you in case there's a buyout agreement. So I'll talk about that in a second. The buyout agreement is another sort of settlement that you could reach with your soon-to-be ex. And that's in the case where you believe that that's more of an equitable division of your properties, or there is no other way for you to get other assets in exchange for giving him your 50% interest. So, or giving him or her your 50% interest. So in that case, you would have a promissory note where he promises to pay you. The promissory note will have details of the terms of your agreement, the terms of the debt that he owes you, which would typically be the date that the agreement was reached or that the note was signed. It will have the total amount, which is the principal amount of the debt or the buyout amount. And then it will also have the interest rate that will be charged, and whether it will be charged outright as the payments are due, or whether it's only triggered if he should default on his regular scheduled payments. And it will also talk about the schedule of the payment. What day of the month is he supposed to pay, or is he supposed to pay weekly? Is he supposed to pay monthly? Is he supposed to pay you quarterly, and on what day? And what constitutes a late payment? How many days does he have to be late for us to count it as a late payment? And then also, what is the late penalty fee? What is the maximum late penalty fee? And what are your rights in the case of a default? So your rights in the case of a default will be what I just talked about earlier. All those terms that are inside the deed of trust should still be in there. And it should say, in addition to that, that if he falls behind on your buyout payments, not just on the mortgage payments, because it's possible he's paying the mortgage company and he stops paying you. So if he falls behind on the prior lien payments, yes, of course, you can move forward with a foreclosure, or you can step in and start paying the mortgage and get reimbursement, as I said before. But if he continues to pay the mortgage payment, the property taxes, and the insurance, the homeowner's insurance premiums, but he's not paying you for your buyout agreement, then you should also be able to move forward with a foreclosure. And then you take the proceeds of sale and distribute out in the order that I mentioned before. So that should definitely be in the deed of trust this time around if there's a buyout agreement. And a lot of the times the deed of trust will be named a little bit differently. It will be called a deed of trust to secure OLT lien, or a deed of trust to secure OLT of partition, OLT, OWELTY. And you can look that up. So that is essentially saying that there was an agreement for the partition, so the portion that belonged to spouse B, there was an agreement for spouse B to transfer that portion to spouse A in exchange for a certain amount of money. So that's all it is, except that there might also be a mortgage in the back end. So that's why it's a two-layered promise to pay as opposed to the deed of trust to secure assumption. All right, so you have the promissory note that also comes along with that one, because there is a debt owed to the other ex, to the other spouse. And if you have the scenario where there are siblings involved, it's similar in my opinion, because a lot of the times you could sell outright. If you sell the property outright, it's so easy because all you have to do is pay all the costs of sale and pay the closing costs, the realtors, everything. And then whatever is left, you divide up evenly, unless there's some reimbursements due that were agreed upon or ordered by the court, then you could do that. But once you sell the property, then that's pretty straightforward. The second scenario is where one child, one of the siblings is really attached to the property and thinks, oh my gosh, it's mom and dad's property. I would love to keep it in the family. And the other ones are like, I don't really care. No, you can have it as long as you buy me out. So remember, we just talked about buyout agreement in the situation where there is a divorce. It's going to be similar. The sibling that's keeping the property will then sign over a deed of trust to secure ulti of partition, promising to continue to make the mortgage payments and also promising to pay all of the property taxes and all the things that come with owning a property and keeping it up in good condition. And then the siblings that are walking away will then have the rights individually to enforce that document against their sibling, and they also would have the right to force a sale if he or she defaults. So that's pretty much it. I'm trying to think what I might have left out, but I can't remember right now. If I do remember anything that I left out, I'll certainly come back to make another video. So essentially, to protect yourself, make sure all the terms are in there about what is a default, and include the right of first refusal in the case where the property taxes are owed, right of first refusal before that ex or that sibling goes to try to get a loan from these companies that give loans to pay off taxes. And so those are the main things that you would have in there, and an assignment of rent is always nice to have in there. And the fact that the other person must seek your consent before transferring title to another party, or else that power to force sale will be triggered. Those are the things that I've really come across. And if you have any other questions, make sure to consult with an attorney that's in your area. They'll be more familiar with how the courts work over there, and they'll be able to guide you better. And I hope, as always, that this video has been helpful and that you've learned a couple of things from here that might be good to know if you ever have a friend that has questions about things like this. But remember to always consult with an attorney for very specific situations. And thank you as always for watching. If you have any questions and text us, you can always drop us a note on our website. And I'll talk to you guys next time. Enjoy your weekend.